because you do everything when you start. You can't be choosy. And even if you're in a specialist set, you have to be prepared to do pretty much everything and be a bit of a generalist at start, because then you can develop your speciality and where you're going to go.
Hello and welcome everyone to our Superlawyer YouTube channel. I'm Divya Dwivedi and your host for the day. Today we have with us Karen Rea, who has been a registered nurse before transitioning to law and becoming a barrister, motivational speaker, writer, and she has been a deputy district judge, UK. She is retired now. Thank you, Karen, for accepting our invitation and welcome. Let me share with you the story behind Superlawyer and what we do here as a team. We try to find super personalities like you in the field of law and get their story to the new entrants for them to get the motivation and inspiration. Let me start with the very first question that we have for you. Karen, you began your career in healthcare industry as a registered nurse before you transitioned to law and became a barrister. What was the motivation behind it? And have you seen any significant influence of your career as a nurse and then moving to a legal practice? Please share your background and most welcome once again.
Thank you. Well, thank you so much, Divya, and all of you. Hello. Thank you for inviting me. I'm very honoured and privileged, and it's great to be here. And just so you know, Divya, my last name is pronounced Ray because when I was at school, no, I'm going to tell you a joke about it, because when I was at school, I was called Karen Rea. And then somebody said, hang on a minute, she's not Rea, she's Ray. And I said, well, yes, indeed. If I had been christened Diana, I would have been known as Diarrhea, and that would not be a good name to have. So that certainly kept them in memory of how it should be pronounced. It's Irish, actually, so it's Ray. If you go to County Cork in Ireland, they all know how to pronounce it there, but nobody else in the world knows how to pronounce it. So please don't worry, Divya. I started off life, I was, I suppose, about 7 or 8, and I remember being incredibly interested in a picture I saw of a barrister. And I remember in those days we had something called tracing paper, and I traced the diagram or the picture of the barrister with the wig and also the pink ribbon that they tied around the briefs. And I actually traced it onto tracing paper, coloured it in, and said to my mother and father, I want to be one of those. So when I was very young, I kind of knew, I had no concept whatsoever what it entailed, of course. That's what I knew I wanted to do. And that stayed with me all the way through primary school and secondary school until I got to about 16. And I decided then, I don't know whether it was the hormones kicking in or what, but I decided I definitely didn't want to sit in some dusty old library being a boring old lawyer. I wanted to go out and earn money and party and enjoy myself. And my mother looked askance at me and said, well, what are you going to do if you don't become a lawyer? And I said, well, I don't really know. All I know is I don't want to be a lawyer. I should have added the words yet. And she said, well, I don't know what you should do. Perhaps, and it was back in the late 60s, early 70s, she said, well, perhaps you can be a secretary or an air hostess or even a nurse like me. And I said, oh, I can't do nursing. That's terribly bloody and messy. And she said, oh, don't worry about that. They suck it all away these days. It's all very modern. Don't worry. Go and be a nurse. So I went off to various hospitals in London for interviews and got accepted at all of them. And I chose the one where the uniform wasn't as long as all the rest. It was actually shorter, and where the view from our flat, because we were in flats, was across the River Thames to the House of Commons. So it was St Thomas's Hospital, which is right opposite the House of Commons, the Houses of Parliament in London. It was a very, very amazing place, fantastic location, fantastic social life. Just cutting a long story short, 3 years of great social life, a lot of learning about the human body, of course. And I started from zero, ground zero. I had no clue whatsoever about the human body. I learned about that quite quickly. But what I didn't like, I'm afraid, was the almost military precision of the way that they did things, where you really weren't allowed to even talk to the patients. You had to get on with tasks all the time, very task orientated. It was the days before nursing was a degree. So it was an apprenticeship where we learned hard work, very hard work on the job, early morning to late at night. And we had to do our exams and our revision in our spare time when we came off duty. So it was a very, very hard 3 years. It was extremely tough, but very enjoyable at the same time, although there were great moments of huge anxiety and knowing, I was absolutely knowing from about day 2 that I was in the wrong job. It was as simple as that. I knew I was in the wrong job, but my mother said, you started, so you've got to finish. So you've got to get the qualification, at least get something under your belt. So after 3 years, I managed somehow or other to scrape through and get the state registered nurse exam and pass it. And I became a staff nurse. I stayed on for a few months at St Thomas's being a staff nurse, but already then I knew I wanted to be a lawyer. And I'd had a girlfriend who'd been doing law for the 3 years while I was doing my nursing. And almost every other month, I was down at her university visiting her, trying to find out what she was doing and so on. And on my days off when I was a nurse, I used to go home to my parents' house and I used to go to the local court on my days off and sit, from 10 in the morning to 4 in the afternoon, just lapping up all the cases I could hear. And it was a criminal court. So it was fascinating to me. And I absolutely knew from then on that that was what I should have done. And not just becoming a solicitor, but a barrister. I wanted to appear on my feet in the wig and gown. I wanted to be an advocate for people. So that's what I did. I came home from my nursing and I went to a local college to do my law degree, where they accepted me quite quickly. And I did 3 years of my law degree living at home with my parents. But what I did then, basically the Bar Council gave me dispensation to continue working at the weekend as a nurse if I wanted to. So I did night duty to get money together at the weekend as a nurse and in holidays. So I kind of kept the two running parallel, because the bar is self-employed and it's very uncertain income indeed, even now. And so it was quite important I didn't close the door completely to nursing as a career later on, should the bar not have worked out. So I carried on, plodded on, got my law degree, during the course of which I had the most wonderful, again, social time. I set up a drama society. I became secretary of the Lawyers Society. I did a lot of mooting. I just got involved 100% in everything I possibly could. How I got a degree at all, I don't know, because we were in a market town called Chelmsford in Essex, and the market hours meant that the local pubs were open 24 hours a day. So my friends and I were well oiled a lot of the time, I can put it like that. We had a great time. And I did some bank or agency nursing, as I say, as a part-time, as spare, to keep myself going. And then, having done that, I managed to go in and get my bar finals under my belt. I applied for that and did that. And somehow in that year managed to revise enough and do enough work to get the exam for that. And then finally being called to the bar at Gray's Inn, my inn, in 1980. After which, of course, then there's pupillage and so on. It's quite hard. There was 2 6-month pupillages. And you were only allowed to be on your feet earning your own money and representing people in the second 6. So the first 6 you had to support yourself. And my parents, were not incredibly well off. I had no legal connections at all, nothing. So, but that's perhaps another question. I'll tell you about how I managed to get into the law with almost no money, no legal connections, nothing at all. But I think it was just the verve and the determination to get away from nursing and to take myself into the arena that I really loved, and that I came to recognize in the 3 years of nursing that I loved more than anything, and still do to this day. So that's the story of how I came. And I will say, Divya, that there are great similarities between nursing and between the bar work I was doing, or indeed any lawyer. So if you're a lawyer and you're representing somebody, they're either been arrested or they've been beaten, or domestic violence, or indeed thuggery in the streets, whatever you want to call it, or they're in debt and they're about to be taken to court and to lose their home perhaps, or to lose money, more money. Any kind of example like that, you're going to get somebody who is at the rock bottom of their lives. When you're in hospital nursing, you're nursing people who are at the rock bottom of their lives. They may often have cancer, they may see a prognosis of death around the corner. They may have a very serious operation expected and they don't know whether or not they're going to survive it. So all of those things, if you look at the two camps, they're very similar. You're looking at representing or advocating for the human being, often at their rock bottom. And in those moments where you represent them and you do things for them and you come out the other side And sometimes you win, sometimes you lose. Sometimes patients die, sometimes they live. Sometimes clients get convicted and go to prison. Sometimes they get acquitted. When it goes well, I can tell you the joy is absolutely phenomenal, whichever profession you're in. So there we are. That's a really good parallel about how the two careers do meet, weirdly.
You have connected these two careers like anything. You actually meet clients at the rock bottom and you
Yes.
take them forward, pull them out of that, and give them a better life, hopefully,
Yeah.
if they pull through.
Yeah.
Definitely. But as you said, we would love to hear your story of doing all this during your remarkable journey. I would love to ask you to share what are these titles and how these roles have given you that spirit of taking all the challenges heads on, and the kind of experience you had when you became deputy district judge and you were there as a deputy district judge for 25 years. How has all this been achieved from, like you said, from not having that much money to reaching such pinnacles of careers? We would love to hear that story, and we want that inspirational and motivational story.
Well, it still applies now, but when I was an undergraduate living at home, doing my bit of night duty at the weekend, and then joining an inn, basically when we were doing our law degree, somebody said in the first or second year, well, it's very wise to join an inn of court because that's the sort of fundamental concrete upon which the bar is based, or was at that time, and still is. Your inn of court stays with you for life. And it's like, your own club, your own private club, for which you do not have to pay subscriptions, I hasten to add. And so what I did, I looked at the 4 inns of court in London, the Gray's Inn, Lincoln's Inn, Inner Temple and Middle Temple. And I saw that through my college, a couple of people knew people who knew people who knew people at all of the inns, but in particular at Gray's Inn, which was interesting because it is just up Chancery Lane from the High Court, and it's not in the Temple, it's just outside. So I applied, as it were, to join that and got sort of seconded by these people who were through my college. And I joined the inn. And in those days, they abolished it only quite recently. You had to dine so many dinners, have 36 dinners, I think 12 a year for 3 years or something. I can't remember exactly, but it was a lot of dinners. And you couldn't actually be called to the bar until you'd eaten all the dinners. And there's a reason for this. And it still pervades now and should be remembered by people who are thinking about the bar and dining in. Essentially, you're meant to go to dinner and it's a great palaver. There's a huge traditional, you sit around in messes of 4 and you have to toast each other. And you have to talk to the mess above you and the mess below you. And you have to integrate, you have to mingle, you have to network, but you don't know you're being made to do it really in a way. So you're just having a jolly, jovial evening, drinking a little bit too much port, I expect, and eating a bit too much food, which excellently cooked food. And you basically end up talking to people who are either on your par with you in college, doing perhaps their bar finals, or just qualified, maybe already called to the bar, who are looking for pupillage, or those who have actually got their tenancy and they are established in a set of chambers, and you're mingling with them all and talking to them all. And it was vital for me because what happened one evening was about in the middle of my second year of my law degree, when a chap was chatting to me. And we got talking about the fact I had been a nurse, and he was talking about the fact that his pupil master did medical negligence in the chambers that he was in as a pupil. And he said, I think my pupil master might be quite interested in talking to you. This is me, who's got no legal connection at all. So I said, oh, all right. I was completely, naive. I said, oh, that sounds good. He said, well, here's my phone number and let me take yours and so on. And he told me later, actually, he had a bet with a male friend to see how many women they could chat up that night. And he lost the bet because when it came to talking to me, he stopped because he was so enthralled with my background as a nurse and got chatting to me about something that was not to do with chatting me up, which was nice. So I then wrote a letter because those days there were no emails, no internet, no mobile phones. It was all done by leg, literally, and by letter. And you had to wait for the postal reply. I wrote to the pupil master concerned, who was a member of Chambers, senior member of a Chambers called Fountain Court Chambers in Temple, one of the top medico-legal sets in the world, never mind in the country. And he immediately wrote back and said, come for an interview. I actually took my mother with me. I was so terrified. And I went in for this interview and he cross-examined me about my background and my ambition and my enthusiasm. And did I want to specialize in medico-legal work? And I said I did. So basically, he offered me there and then a 6-month pupillage at the end of my bar finals. I had to get my degree first, and then I had to pass my bar finals. But at the end of all that, he gave me a 6-month slot that I could go and be a pupil with him doing medical. I was thrilled. It was only later I realized what an amazing set of chambers they were and how it would look so good on my CV. So that was number one. Then I began to think about what about the second 6 months? I better do something about that. And by then I was already mooting secretary, Lawyers Society secretary. I was into my 3rd year. And the judge, the local Crown Court judge, whom I'd obviously told him as a nurse, I'd been on my days off to watch all the trials there. He was absolutely enamored and he offered me a pupillage in his set where he was as a barrister before he became a judge. But luckily by then I'd already got through Gray's Inn an interview with another set that did crime. And that particular person lived fairly locally to where my parents were. We didn't know each other at all. And he offered me a pupillage seat for my second 6, where I would start literally on my feet, representing people for the first time. So by the time I finished my law degree, I had got myself completely set up. And that was purely through networking and being part of and a member of an inn and using as many contacts in my university or college that I had. And also placing myself in a position where somebody said to me, if you become mooting secretary, apparently the judge always asks the person who's mooting secretary to go and join their chambers for pupillage. And I knew then that's what I should do. So I went and lobbied all my friends and they voted for me and I became mooting secretary. So it was all political with a small p, but I had in mind, it was a sort of an ambition that I knew which path I wanted to go, i.e. to get pupillage. Well, after that, I had no clue. I just get the pupillage because I had no legal contacts at all. So that's what I managed to do. And I managed, as I say, scrape through the degree, despite putting on a couple of productions in the Drama Society at the college, and then going on to do my bar finals, which were very tough. It was 1 year of learning about civil and criminal procedure, all the things that make you practice on your feet. So suddenly, from a degree where it's all academic and you're learning the case law and all the rules, the rule, the exception, the case supporting it off by heart, ready for your exam. Then you come to the practical side, which is the practice course, which is now much more geared to practice than it was in my day. And when we had to learn civil and criminal procedure, among other things. And that was 1 year and there was no holidays. I think we had 2 days off for Christmas and 1 day off for Easter, and that was it. So it was a complete full year, full on. Managed to scrape through that, although my girlfriend failed it and had to retake it in September. That was a very high failure rate. And then we came out, and that was when I was called to the bar. And finally, my parents were able to see me in a wig and gown established, and I went into pupillage. But then, of course, in pupillage came all the trials and tribulations of learning. You are at ground zero. You literally are at the bottom rung of a ladder. And then you have to find a tenancy, which is a permanent place in chambers, a proper job, in other words. And that was very hard. I ended my year's pupillages, 6 + 6 the year. And by that time, being on my feet, I would also say one thing to everybody listening. If you are a potential barrister or an advocate, and you have friends in an undergraduate environment who want to become solicitors, who do not want to go and appear in court, who do not want to speak in court, but who will be dealing with the lay client, then make good friends with them, please. I was able to make very good friends with several people, genuine friendships, and one, if not 2 of whom, saw me through my first 5 years as a barrister, because they went into their firms of solicitors and they said, oh, we're going to give Karen Rea that brief. And so I actually got my own briefs from my own solicitors without having to rely wholly on the second set of 6-month chambers, which was very powerful, because when you come to move to a tenancy, if you have your own practice and you're taking that with you, you are offering, in effect, a potential source of income for yourself and, of course, for the chambers, because you're bringing money into the chambers that you're applying to. So it becomes quite important. Again, friendship, networking, really important from the get-go, really, from the day one. Just make it your mission to think, well, I want to be friends with these people because I really like them, but also there's an added bonus, which is that they could perhaps be part of my professional life later on. And that's what happened with 2 or 3 of my friends. And one sadly passed away last year. So sad. But he saw me through for the first 5 years of my career at the bar. Without him, I don't know where I would have been. And so when I went off to apply for tenancies, I had this portfolio I could take with me. And I had the list of solicitors and which sort of law, crime or civil or even family, immigration, licensing, everything, because you do everything when you start. You can't be choosy. And even if you're in a specialist set, you have to be prepared to do pretty much everything and be a bit of a generalist at start, because then you can develop your speciality and where you're going to go. I mean, clearly for me, having been a nurse, medical negligence or clinical negligence was going to be an option. But as it turned out, when I got my tenancy finally, I ended up doing way more crime than any kind of civil. And it was only after 10 years in chambers that I actually turned to doing my regulatory and healthcare work more than before. So when I went off to get my tenancy, in those days, no internet, as I say, no mobile phones, nothing like that, all by letter. But in my case, I decided to put in my briefcase about 25 CVs, and I went on foot to every single chambers in Temple, Inner Temple, Middle Temple, Lincoln's Inn and Gray's Inn. And I footed it round. I literally walked to every single set. And I walked in and I said to the clerk, I'm Karen Rea. Your chambers need me. Here's my CV. Thank you. And they said, oh, we'll give your CV to head of chambers. And I think I was interviewed several times, perhaps up to 10 times as a result of that. And of course, didn't get in anywhere at all. And after 18 months, so 12 months pupillage, another 6 months where I was hanging around chambers as what they called most ungracefully, I think, as a squatter, because that's what you were known as in those days. You weren't a pupil, you weren't a tenant, you were merely a squatter. It was only then I came home and there were 20 of us in chambers who were squatters. And the head of chambers decided to give us notice to quit and to get rid of us all. He gave us about a month's notice to get out. And at that stage, then I came home to my parents and I cried my eyes out and I said, well, I'm going to have to go back to nursing because I have no tenancy. I have no ability to earn money if I don't have a set of chambers. And my mother then got very angry and she said, well, I think you're just going to have to ring up that judge in your university, in your college, the one who offered you that pupillage way back when you were mooting secretary. I said, I can't do that. She said, there's no such word as can't. Do it and do it now. Well, she was terrifying, my mother. So I did. And actually, I got halfway through the phone call. I got through his clerk to the judge, and I actually broke down in tears saying, I've got all this work, I've got all these solicitors, but I had nowhere to go. He said, my dear girl, I'm not having that. Come and see me on Monday morning. And by Monday morning, he'd phoned up an old friend of his called Tunji Sawandi, who was head of chambers in a very small, very kind of almost not quite proper set of chambers in King's Bench Walk in Temple. And he had fixed me up with a tenancy with his mate. I couldn't believe it. He phoned me up. He said, come and see me. And I went to see him quivering in chambers, in judges' chambers. And he said, go and see Sawandi tomorrow in London. He has a place for you in chambers. And I went to see Sawandi. He was a remarkable man. He was the first Nigerian black barrister at the bar who was head of chambers. He was also the first black recorder, and he dressed in the most elegant waistcoat, and he was absolutely immaculate, and he made sure that we had to go to court immaculately as well. He was also our granddaddy. You know, he looked after all 10 or 12 of us that were in that set of chambers. It was certainly not a high-flying set of chambers by any set of the imagination, and I really needed my own solicitors in that set in order to make sure I carried on working. But when I got there was no proper clerk. So I went back to the second set where I did my 6 months. And I asked the senior clerk there if their junior clerk could be spared to come and be a clerk in our set. And he said, oh, yes, we don't need her. And he let her go. And Kim became our clerk in my new set of chambers as a tenant. And it so happened her father was quite a big name in one of the leading criminal sets in London. And as a result, all the members of that chamber suddenly got tons and tons of criminal work, earned a lot of money, and we became very well known. So it was absolutely wonderful. It was just such a fortuitous set of circumstances. But again, it was all spotting the opportunity, really, and having a hard mother behind me, for sure, but also spotting the opportunity when I was there. I saw no clerk. I thought, well, hang on, this can't be right. We will not thrive as a set of chambers without a clerk. So I went to see Sawandi and said, look, I know you've been around forever. I know you know the business, but I think you need a proper clerk. And I know I'm only a baby and a junior, but there is somebody available. And he said, all right, let me meet her. And he met her and I brokered it. And we had a future in that set. And I had a future. I stayed there about 8-9 years before I went off to a civil set to start my civil practice in medico-legal work. But it was such an exciting time. And as I say, starting at the bottom with no connections whatsoever and just spotting the opportunities and using your head, really, using what you have and not necessarily relying on others, but taking the initiative. I think that's what's really important. So I hope that gives you an idea. I'll come to the DDJ thing. That goes a bit further along, because what happened then, I then spent a number of years doing civil work. And after about a few years of that, I saw an advert in the newspaper, in the Times, for a medical negligence practitioner required by Guy's Hospital, who were down the road from St Thomas's, where I trained, along the River Thames. And they'd fought that eventually they're now part of the same group. King's, Guy's and Thomas's are one group in London. But then they were separate. And I then thought, oh, medical negligence litigator, I wonder if I could do this whilst still being self-employed in chambers as a barrister. I did not want to become an employed barrister. And so I went off and I had about 4 or 5 interviews for the job, and I got the job, only it wasn't. I insisted that when they offered it, that they gave me the right to be a self-employed barrister. So I then had to find a firm of solicitors, and I got one of my civil firms to give me, as it were, the briefs. So every single file that I opened in the hospital, a brief was opened for me to act as a barrister, but also to make sure that I was running the department. So I actually ran the medico-legal department of Guy's Hospital from 1989 to about 1996. And what happened then was one of the chief executives at Guy's, who were linked with Lewisham Hospital in southeast London, they went off to start a new trust in Dorset. And they asked me to set up the same system on my one day I had left a week in Dorset. So I did that for 1 day a week, and I did the Guy's work for 4 days a week. And again, the Bar Council had to give me special dispensation because in effect I was on site. I actually had an office in the corridor of power. I liaised with the finance officer. I liaised with the chief executive officer. I had to report to the board every month. I had to provide the budget. I was given a budget and I had to show how I'd spent it. I had to actually work out which cases were to be settled, which cases were to fight, and those that were to go to court. I actually represented the hospital in court, not only in the medico-legal work, but also the public liability work, employers' liability, the tripping and slipping cases, and also in the coroner's court as well. So it was a hugely innovative and busy time. I was probably the first barrister who had ever done that kind of thing, and a number of people were quite concerned about my position, because at that time, as you know, at the bar you could only go to court if you were instructed by a solicitor, who in turn was instructed by a lay client, whereas I seemed to be cutting out the middleman and going straight to the client. But in fact, the Bar Council said, no, you're doing it appropriately. We have banking lawyers who do the same thing in the Bank of England. They go into the vaults in the Bank of England and work on the files there. That was back in, as I say, the 80s, going into the 90s. So it was a very exciting time. And I was doing it in the medico-legal field. So it was innovative and different. And it was at a time when we had the old health authorities in the UK governing, as it were, the healthcare sector. But that changed in 1989 to the NHS trusts. And the trust I was actually with, the health authority I was with when I was recruited, was the Guy's and Lewisham NHS Trust. It became that in 1989. And I was in that corridor leading the way with the others in that corridor, particularly, of course, the chair of the board, the chief executive and the finance director. But I learned in a one-in-one learning curve. I was still a member of the bar. I was still going to court. I was still doing all the things. I was still in chambers, doing all the things that I had been doing. But I was also, with another hat, I was learning about how budgets work, particularly when they're treasury-led from government, and how when the government releases money to the Department of Health, for example, or indeed the Ministry of Justice, they release money every April. And that money is available to spend, but it has to be spent very carefully over a 12-month period. So at the end of the 12 months, if they haven't actually spent all the money, they know they're not going to get that same money next year. So suddenly everybody's spending money between January and March of any one year, which is why we see, well, we used to see, not anymore in Britain, we used to see the roads being mended like mad between January and March. And we saw a lot of cases being settled in medical negligence between January and March every year. It's a drip feed way of progressing, and it's not healthy, it's not ideal. But it certainly taught me about how government works with a big G. And it was very, very interesting and something I'll take with me forever. And I then went back to working in chambers, purely doing personal injury and medico-legal work. And that's when my regulatory work came into play, where I saw various advertisements for becoming a legal assessor or legal advisor to the regulatory bodies who regulate healthcare and financial and lawyer professionals. And I started out at the Health and Care Professions Council and General Medical Council, and I developed that into the General Dental Council, Nursing and Midwifery Council, and went through to a number of different financial bodies, the Chartered Institute of Public Health Accountants, CIPFA, and the RICS, who are the surveyors. I did work for them. I must have at one stage had about 12 different organisations that I was legal assessing for, legal advising for. And that basically is where you're doing legal advising to a panel who's making decision on what we call fitness to practice. And I'll come back to that a bit later. So that's what I do. I do that now, and I do that as a portfolio career, and I only do that now. I don't go to court for individual clients. I only do the regulatory legal assessing work these days. And then along the way, as you quite rightly pointed out, there was an advert in 1998 for deputy district judge in the county court, civil. I thought, well, I've been doing civil for long enough now. Perhaps I should try to climb on the judicial ladder and see what it's like. And so I went for an interview and passed muster and got offered a deputy district judge post in 1999. And that was a one-in-one learning curve, because as barristers, we don't do, unless you specialise in family law, which I did not want to, and at all costs, we don't do costs. I think young barristers do now, and I'm in total awe. But for the whole thing, it was all about debt, costs, family, breach of contract, all sorts of these, enforcement of judgments and so on. It was the county court, the lower level. And I remember going on training. We were in training for a week, and I came out with post-traumatic stress disorder. It was the most alien and strange thing I had to suddenly learn and be on top of and be ready to go into court and be master of or mistress of. It was quite scary. But as the years went on and I did more and more cases, or part-time judging, I decided I wasn't going to be a full-time judge. I didn't like the idea of personally being kind of shackled to a full-time judicial post. It's actually quite lonely, and I think it can be quite mind-numbing. So I like the idea of being free to be self-employed barrister one day and a judge another day. And it worked, I think, very well. I was absolutely thrilled to carry on doing it, and happily have been doing that, as I say, until March this year, when I retired, but during the course latterly of which I've been asked to advise the Civil Justice Council on the future of civil justice with regard particularly to artificial intelligence. So it's all very exciting. And one thing has led to another, to another, to another. And that's how my career has been. And some of it totally unplanned as well, which is a nice thing, I think. It's a good thing.
But most of it very well planned, I would say. And you cannot just say that it was because of networking. It was because of your smart thinking. It was because of your consistency. It was because of your hard work that you put in. Nothing can be achieved like this. The way you are telling it may currently feel like it's a fairy tale story, but while I was listening to it, it was like, oh my God, so much hard work has gone into it. And she is so conveniently saying that it is only networking. I cannot accept that. And I'm sorry I'm saying that, but that's something which you have done and shown. And I am feeling right now so much proud that you accepted my invitation to be here. And I was unable to interfere in between because you have so much to share with us. It just cannot be contained in such small unit. I'm telling you, it is epic, and it should be in volumes, because
Too much.
every segment of your life is a learning curve, and we will learn so much from it. even a segment of being medical negligence, any part of it, any part. It's so mesmerizing, but I cannot do that right now. So I'll move on and ask about another chapter in your life which you have done. You have been an expert voice on clinical negligence on radio programs with BBC Radio 4's, where you were there as you and yours segment. How important do you see is media engagement for legal professionals? And how have you seen this particular approach of yours has broadened the horizons, as you were saying that one thing led to another? This I want to understand.
Yeah. Well, it was basically an expert obstetrician in one of my cases. It was around the time I was applying for deputy district judge when they actually asked me to apply. In Bristol, they were doing a round country thing to try and recruit more judges. And they said, oh, you'd be ideal as deputy district judge. And I said, well, I don't know. It's quite low down the order of things. I was thinking a bit more senior than that, really. I was very arrogant. And I said, the reason is because I have probably 10 cerebral palsy cases on my desk, each worth in those days £1 million or more in damages if we win, which now cerebral palsy damages cases have gone through the roof. You know, you're talking telephone numbers, tens of millions very often. And I'll come to the reason why in a moment. I remember that feeling of, oh, really? I've got these terribly important cases on my desk. Why would I want to be doing something like deputy district judge? Well, thank goodness I actually swallowed my pride and did actually apply, because I'm glad I did. But in the cerebral palsy cases, just so you are all aware, what happens is, and I get cross about it a bit, when you're in labour, there is this window of time when the baby wants to come out, and this is an example, and maybe your body doesn't want to let the baby come out for various anatomical reasons. And it's in that period of time before anybody decides to do a cesarean section, but where they are gallantly and heroically, although I question the word heroics, trying to do forceps delivery or ventouse or whatever. And this is where the brain damage can occur because of the lack of oxygen to the fetus, to the baby. And often, I've seen it so many times, you can actually count the number of seconds or minutes on the CT-gram. You know, everything is there and monitored, and you can see how minutes are passing, minutes where things could have been done, action could have been taken, and it wasn't, because people were bravely trying to do it the way it should be done. And it was always my view that, you know, cesarean section, albeit it's an abdominal surgery and you are laid low a bit, you're not allowed to lift things for 6 weeks afterwards, and you're allowed to drive for a month and so on. Fair enough. But at least you have a baby that's A, alive, and B, has got a brain that functions. So when you have cerebral palsy cases, it's where things like that can go wrong, that often, not always, often, I think, and this is my own bugbear and has been from, you know, the moment I started learning about it as an undergraduate, often is avoidable. And I had many cases like this. I fought and hopefully I won. But along the way, we would have many experts in the room on conferences. And they'd be neonatal experts, they'd be obstetricians, they'd be neurologists, you know, all sorts of different experts in the room. And one of the experts was David Boggood. We had a wonderful conference on one of the cases. I can't remember which one now. It was years ago. And at the end of it, he dropped me a note and said, would I care to contribute a chapter to a book he was writing on obstetrics and gynecology. But basically it was obstetric anesthesia, because we often need anesthesia experts in the room, because obviously that's part and parcel of the oxygen deprivation argument that one might have, and the causation argument as well, of course. The defense, by the way, a lot of the hospitals and obstetricians would be, oh, the baby would have been born brain damaged anyway. This is what we call the causation, the but-for argument, the Bolam argument. So I'm very keen on the whole duty breach and damage, the whole of the area of the law of tort. I love the law of tort, and I'm particularly keen on causation. And so my chapter was dedicated to that, care of David, who asked me to write it. It's called Negligence and the Obstetric Anaesthetist. And I explained there that the entire test, the duty of care that's owed to take all reasonable care, the breach of that duty when things go wrong, and the ultimate damage to the child, and often actually to the mother too. That's more surgical. But the sticking point always is causation. But for the thing that went wrong, and let's assume for the moment something goes wrong. Okay, hands up, it went wrong. We know it went wrong, but it did not cause the damage to that child. And that's the causation argument under Bolam. So it is important that it all links up. And that in turn was kind of linked in with a number of other things I did. So what I was keen was to make sure that the message was got across to as many of the readers that were going to buy the book as possible. I mean, the book was published, I will say, Divya, in 1995, so a long time ago now. There's other case law that's caught up and overtaken. But what I also did in those days, from about 1981 or two, I'd just been called to the bar, and I was just starting out as a pupil barrister. And when I was at St Thomas's as a nurse, I've got to put this politely, I used to get in quite a lot of trouble because I used to say, why a lot? Why are we doing this? Please explain. And they didn't like it. It was the 70s, 72 to 75, a long time ago. And it was the days when literally some of the case law used to refer to nurses as being doctors' handmaidens. Literally, you do what the doctor says. You don't question. You do what nursing sister says, the sister of the ward says. You do not question. And I could not believe it. I mean, I was coming from a wonderful family, a great school. It doesn't matter where you are. If you come from somewhere half reasonable that teaches you that something isn't innately right, then you know it, don't you? Almost instinctively. And it didn't seem to me, even though nurses were seen as doctors' handmaidens, they still need to know when things go wrong and how far they can go or shouldn't go. So I basically was always asking why and got on their nerves a lot. Anyway, when I left and I got my badge and I was safely out of nursing and out of the zone, the former head of nursing of St Thomas's contacted me. By that time, I was a pupil barrister, I think maybe about to get tenancy, actually, as I'd explained. And she wrote me a lovely letter and said, we think we need you to come and speak to the King's Fund Centre about something new that's happening in nursing called the nursing process. And that was a new way of recording things. It had an eye more on the legal, if it moves, write it down because you might be sued. It was defensive. It basically, people were frightened, hospitals, doctors, nurses, everybody was frightened of being sued for large sums of money and getting larger, as I've already exemplified by the day. So I said, oh, yes, I'd love to. Again, I tripped along. I was very earnest. I spent about 2 solid days preparing my lecture to them, and it was going to incorporate tort. It was going to incorporate my favourite subject, negligence. It was going to incorporate duty, breach, damage, and I was going to incorporate causation. Whether or not it had anything to do with record keeping, I didn't really care. All I knew is I wanted to get the message across. So I dutifully turned up, all wide-eyed and innocent, and this absolute bank of people. It was actually held in the St Thomas's Hospital old lecture theatre, which was sort of the one where actually all the seats go up the wall right to the top, and they're all wooden, and it's quite large. It was packed, and I didn't know at the time, but it was packed with senior nurses from all over the country. Anyway, I gave the lecture, and at the end of which, the lady who invited me actually said that she told the audience she thought that when I was nursing, I was a square peg in a round hole. And I thought it was her way, actually, quite nicely, of apologising to me, because they did give me a hard time at St Thomas's. And I think it was because I was questioning and they weren't ready for that at that stage. And by the time it came into the early 80s, things were changing. The degree that we were on the way to Project 2000, the degree for nursing was going to happen within a decade. And I think people were realising that we weren't just doctors' handmaidens, thank you very much, and we had a voice. And I was determined to give the nurses that voice. So what happened as a result of this particular one lecture in 1982, I spent, without a single advertisement, I spent 15 years or more giving lectures all around the UK to almost every single hospital. and a couple in abroad as well, in international nursing and law conferences that they had. And I was talking about duty, breach, damage, causation, but in particular about two aspects of tort that still, I think, are important for everybody, no matter whether you're a nurse or not. And that's primary and vicarious liability, where you have primary liability, where you are liable in your own name, and vicarious liability, where your employer will take liability for you. But the law makes it quite clear that if you act on what's called a frolic of your own, and you do something outside your contract terms of employment, you are on your own and suddenly you're liable. So I used to lecture the nurses about this, and I used to tell them, whatever you do, because basically you seem to be jack of all trades and master of none. You know, nursing can be as technical as almost medical work. It can be as menial as auxiliary work. It goes from one end to the other in its job description. And there is no proper job description for nursing. It can be anything that anybody wants it to be. So if a doctor swans into the ward or into the unit and says, oh, can you do this ECG for me? And you do an ECG, you've never done one before, and you don't know when it goes into abnormal rhythm, you've got problems because you've agreed to take something on that you're not actually qualified to do. So I was very stern in my 15 years. I made quite clear what nurses should do. And as a result, I think I'm hoping a lot of nurses became lawyers, having heard me, quite a few. And I think the message got across because eventually it became quite the norm for people to be rushing down to the personnel, or as it was called then, the HR department, to find out what their job description said, so they knew what they were doing. So that was all very exciting. There was the book writing, there was the lecturing, and also being on the radio, as I say, for you and yours. And also, Divya, I was also an agony aunt on local radio. And that was through just somebody I'd met at, I think it was some drinks party through my university. And then it was some years later, I was already at the bar. And he rang up, and he was a DJ on the local station. He said on Sunday night from 10 o'clock till midnight, he had a 2-hour agony aunt thing where he wanted me on board with a doctor and a priest, believe it or not. And we had phone-in going on. And it was hilarious because some of my colleagues at the bar would be listening. And by the time I got to the robing room the next day, I was being ribbed mercilessly about various questions that were coming up on the programme. So I had a tremendous amount of fun. But where you have to be very careful with my radio work, from time to time, you and yours came to me for the odd topical thing that might have cropped up that was medico-legal-ish. There was one involving somebody who'd been dismissed for being overweight, what we might call weightism, if you like, today. So I remember having to come out of court and asking the learned judge for a few moments as I had to go and appear on the radio. And he gave me 5 minutes to go and whip into the reception area and go on the phone and be on the radio. It was hilarious. But you have to be very careful as a lawyer, as a barrister in particular, about radio appearances, television appearances, because really it's not permitted unless you're giving advice. The advice can't be about an individual case. It must be general. And there are strict rules, and you can be held in breach of your bar code or indeed any other code in your profession. And you have to be very, very careful. And what we're seeing in regulatory law now is a huge increase in allegations of misconduct relating to misuse by professionals, be they doctor, dentist, healthcare professional, accountant, lawyer, doesn't matter who you are, misuse by professionals of their social media. So one has to be super, super careful and remember always that you owe a duty to your profession and to your public to always remain with integrity. It is vital. So yes, media can help, but only in a limited way.
So true. These topics, these points are so big that they cannot be contained in like 1 second, but we have to ask other questions also. And your involvement with lecturing about the impact of AI and machine learning on the litigation and the judicial system or justice system, which you recently started doing with several of the think tanks like MKAI and For Humanity.
Yeah.
What are the examples that you think are very important with these disruptive technologies, which are bringing in significant changes in even the legal fraternity and legal industry, and the kind of future developments that you see with which future generations are going to come across and how it is going to impact our, let's say, legal and other backgrounds as well, because you come from such a prominent nursing background, which you have combined it with law. We would love to hear that aspect because you are absolutely involved with AI and law as well.
Yeah. Well, I have to say, we have, as you know, Divya, we have the wonderful Vibhav Mittal over in New Delhi. I love him to bits. And he is the IP, intellectual property expert, of which I know nothing or next to nothing. He's the man you need to get on to talk in detail about that. You must do that. I would advise actually all potential lawyers to think about tech law for a future career. I would also advise anybody who isn't into tech or AI and tech to kind of just learn about it or do the For Humanity certification or just join groups like MKAI, Inspired Minds, all of the others. There's lots of them out there. And I joined purely because I was so intrigued about artificial intelligence during lockdown. And that's where I came into the party and joined the party very late on. And so I'm busy at work and I don't always have the time to catch up. And I have actually got a complete, almost two full shelves of books that are purchased and need to be read on AI that I've got to get on top of. Vibhav and I, we're going to collaborate later in the year as well. I've got to get on top of it much more than I am. But I'm excited by it because I think it can cut out a great deal of boring, mundane aspects of legal work, whether it be researching documentation and case law and making sure that you get the right case law, you get the right documentation in the e-bundle for trial, making sure that you are honing in on the right area of research. I mean, case law has shown us, though, that you absolutely have to have a human in the loop. We know what happened on at least two cases where a lawyer came to court in New York, I think it was, and started quoting cases that didn't exist because he'd been on ChatGPT. But it is important that you do use the tools, but use them as a human being and keep humans in the loop. It's vital. It's really important. So we have things like e-bundles, we have e-discovery, every which way we can use electronic and digital means in order to cut out the dross, if I can call it that, the boring, unnecessary work that paralegals or junior lawyers do, to allow them to concentrate on getting skilled more quickly as a senior or a more experienced lawyer. Why not? You know, let's get people into the room actually doing the hard work, because we need to actually get skilled people there. What I would say, I mean, I'm going to spend the entire day tomorrow at the Law Tech conference in Billingsgate in London. It starts about 9 o'clock and finishes about 5. I've got Richard Susskind, who I collaborate with on the Futures Group, and Christina Blacklaws there. We've actually got Louis Theroux actually as a guest of honour as well. So it's going to be very exciting tomorrow. And it's only after tomorrow I think I'll be able to talk with any degree of authority about what the future will hold, because I'll be listening to people much more skilled and knowledgeable about it than I am. But all I know is that we have principles of cutting out the unnecessary work to allow lawyers to get to the real issues the client want to hear, either by way of advice or in a courtroom by advocacy. E-bundles, e-discovery, you know, all of that is available, even now is available. But what we also have to bear in mind is we must keep humans in there, because we must use them as tools, and we must always ensure that we stay in charge. And with generative AI, machine learning, where they are learning to think on their own, we have to still somehow or other, and I'm not sure how, the technologists will be able to know, we have to still keep the human in the loop, and we have to fight off the big super companies who want to do nothing but make profit. We have to keep those at bay as well, because what we do need is responsible and ethical AI in order to fight off the biases that we're inevitably going to get if we keep on as we are doing. Because if you look at the data, we haven't got data of nearly the whole global world. We've only got a very, very small amount of data. If you look at the billions and billions of people in the world, where's the data on, for example, the indigenous people of Borneo or the other end of the earth? And people talk about the North-South divide. There has been a recognition that in the North, the information and data does not represent the global South. Having said that, I will say that I am in awe a great deal of India that is striving ahead and doing marvelous things. And I think there are a lot of people in the technology world who are thinking that China is also doing a great deal too. But we worry about China, obviously. But I think keep an eye on that and watch this space. What we want is some kind of obviously regulation or standards, some kind of checks and balances to ensure that we do get the proper data, because data is the oxygen of artificial intelligence. It's absolutely vital that we get the right sort of data that is representative of every single nation on this earth, every single language, every single individual. And where I come from on AI with the legal side is I come from the county court, from the judging side, where I see that during lockdown we went remote and we now have Zoom and Teams, the platforms are there and we're having cases being heard that way. And when lockdown finished, Divya, what was so extraordinary was the Ministry of Justice in London, the United Kingdom, decided in 2021 going into 2022, the default position, now we're all safe and free from virus, please can everybody come back to the courtroom? And I thought, why? Why would you do that? Now, there are some cases where you do need live people in a courtroom. You need to be able to have the presence of people. But there are now many cases, and that's been proved, where people either would not have come to court beforehand, but because it's being done by Zoom and they're in their own home, they are less nervous and it makes it more accessible. And justice has been made more accessible since COVID. There's no doubt about it. We are, with Zoom and Teams and all the other platforms, we've become way more accessible. And the attendance rate of people who are either suing or being sued or accused or being accused, that in courtrooms has gone way up, to the extent that there just aren't enough lawyers, I think, around to meet it. And certainly as far as the Ministry of Justice is concerned, there is probably, maybe there might be an agenda as to why they've asked us to go back to court as a default position, because unfortunately there's been a real backlog in the civil courts in the UK, a backlog that is now so bad that is actually going into not just months but years before your case can be heard. And they really need to get back to trying to get as many judges as they can. They're not able to recruit judges easily at the moment. There are a lot of problems with recruitment of judges, particularly at the county court level, mainly because they haven't really been teaching judges properly or in person about the technology. Digitalization has happened. We're making orders online, but it's really hard. And for any one order I make online, I kind of got through 20 paper exercises that I would have done before. It's taking 20 times longer to do one thing, particularly for a part-timer where you're not doing it all the time. For a full-time judge who's doing it all the time, fair enough. But actually, you would end up on the funny farm if you ended up doing it all the time non-stop, because it is actually mind-boggling, because you're sitting at a computer screen all day and with barely a break. It's not right. So there needs to be a root and branch reform, certainly in the UK in the civil justice system. Hence, I'm on the Futures group with the Civil Justice Council with Richard and others. Well, Richard's now left, but there are others who are taking over. It's very exciting. We've got Sue Prince and others who are doing that. It's good because we might be looking at perhaps the metaverse, where you're looking at having something on your head and you're having an augmented reality, if you like, or a virtual reality even, where you can actually have a courtroom pretty much anyway. You could be on a beach in the Bahamas and have a courtroom if you want. But essentially, it means, again, accessibility of the public into having their hearings heard properly. That's very exciting. How that is going to chime with where certainly we're at in Britain at the moment with regard to the finance that's not been given to the court system, with regard to the finance that's not been given to how the court system operates in terms of discovery and e-bundles and all the rest of it. The fact that there are so few staff members, they're overworked, they're underpaid. It is so sad, and things get misfiled, things don't get sent, emails get missed. And it's something we are looking at. We were going to be projecting into the future to 2030 and beyond, and we are still going to do that, but we're actually going to do it by looking first at what the problems are now. And that, to me, is what we need to do, because I still want to be an advocate for the underdog. I still want that member of the public properly represented as we go forward with AI into the court system. So there's lots of pluses, lots and lots of them, but we're in the learning phase at the moment. So there are a lot of hurdles to overcome.
Thank you for putting that point forward that yes, we are in the learning phase, but it is growing faster and faster, and we
It
have to
is.
get ahead of it.
You're
Because
right.
obviously humans are supposed to be in loop. Yes, that is my favorite topic as well. And since I practice IB and tech and all those, so I realized that when you were talking about it, it makes sense when you put humans in the loop to understand how the effect will come out because of the technology disruption, because of all the things going on. And that is why probably I started learning more about neurotechs as well, as in how our brain is going to respond and how that is going to be used for or against us. No idea yet. Yes, we are talking about it in several think tanks.
Absolutely.
So during all this conversation that we have had, I wanted to ask you this particular question in relation to the way you teach graduate and postgraduate law students as well. What kind of insights do you share with them or impart with them, as they are the next generation of the legal profession? And the way you have risen from your career and the way you have used all the circumstances to your advantage as well as your friends' advantage. Not only networking has helped you, it has helped them also to network with you. So what kind of insights would you like to share with those legal professionals who are listening to you here today?
Okay. Never, ever be disheartened. I can't tell you, if I had a penny for every failure in my career from the moment I left school at 18 to now, I'd be a squillionaire. Failure after failure, but I made myself into a rubber ball. I kept bouncing back. Always have your glass half full and never put yourself down. People will put you down. You will think you're being put down because of the language used in a rejection letter or in an interview or something like that. You will think you're never going to get employment or a job or a position. Don't believe it. Just cut off that inner voice immediately. And that's an order, because basically everybody is valuable, every single person. But what you have to do is think outside the box. So if you're in law, then you say, okay, well, I want to do something associated with law. Well, think outside the box. There are all sorts of different things that might be associated with law that you could do, things that are not associated with law, but that are going to hold you in good stead because the skills are transferable, whether you're working in a shop or you're at the end of a line dealing with customer care and complaints in a call center. It doesn't matter. You're dealing with issues, with problems, with human beings who are themselves at the rough end of the wedge, as it were. So what you do is you just make anything you do, turn it, spin it to your own story. Tell your own story in your mind, and everything you do, mold it to your own story. So, for example, I would tell lots of, and believe me, they're pouring out in the UK hundreds and thousands of graduates, law graduates, hundreds and thousands of both barristers and solicitors who pass their finals of the second part of their professional life. And they're there, all of them, in their hundreds of thousands now, all over the UK. And they can't find a job. They just can't find. They send off 250 applications and they might get one reply that says, oh, sorry, no. Most of the applications that they send off, they don't even get a reply to. It's got so rude now. I think it's rude and appalling. If I was an employer, I would, deprecate it. You'd have to employ somebody dedicated to answering all the letters, but at least they get an answer. At least they think they're being cared about. But it's become a very cruel, uncaring, almost sort of harsh world out there. So you've got to build up the defences even more and get even more confident about your own story. And what I say to undergrads, people who are not where they want to be, is go and think about being an employed lawyer, go and think about being an employed paralegal. Okay, employed paralegal. You're a bit of a gopher, A lot of photocopying, maybe, a lot of preparation of e-bundles, maybe, a lot of listening to other people, a lot of running around making coffee. Doesn't matter. The fact is, you've got a toe in that door. Push and push and push. Make yourself invaluable, make yourself likable, you show you're a hard worker, and perhaps that opportunity will come. And if it doesn't, you might have been networking at court or in other places with other people in other firms or in another area. Think about that. Should you apply there? Be cheeky. Ask them. Go round with your metaphorical CV to your 120 sets of chambers like I did. It's a bit like a sawn-off shotgun when you're doing rabbits. I had a case involving that once, by the way, which was hilarious, at the Old Bailey. And basically what they used to do when they shot rabbits was they had a wide range so that the lead would go all around. If you have a wide enough range, you might capture something along the way. So do that. Think about that. Think about academia. Think about, okay, maybe I'm better to study and to get a master's under my belt, although in England, the bar finals count as a master's, but you could do, what I call proper masters, a master's under my belt in my chosen subject. For example, there's a Master of Studies at Cambridge University that deals in AI and ethics. How about that? Well, I'd be off straight away if I was younger and had a few more neurons rubbing together. It is actually so exciting. There's so many techie things out there if you're at all interested in that. It was a day of the dot-com bubble back in 2000. People used to go off, oh, I'm going to be finance, I'm going to do stocks and shares, I'm going to set up my own dot-com company. Well, now it's tech. Now it's AI, machine learning. Go into that. Maybe if you haven't even got an interest in it, just read about it and see, well, maybe I could become a bit of a nerdy expert in this, and go off and think about it either as a career in practice or as an academic. Do some writing, write some articles, write in your own chosen story, your own chosen niche, like I did in tort. I wrote articles for the Nursing Times. I had about 8 of them over a period of 8 weeks. I wrote about duty, breach, damage, causation, vicarious liability. Just write to your favorite magazine or journal, email them and see whether they'll accept getting an article on board from you, or 2 or 3 or 8 or 10. Any kind of thing like that. Try to think sideways, try to think outside the box, because whatever you do, you can make it work for you because you can mold it round to your own story. So that's what I would say. Be courageous, be confident, be ambitious. Never let anything get you down, ever, because you don't deserve it. You do not deserve to be put down.
Such positive advice. It seems that it is not only for new entrants, it's for everyone. If you stay positive and you work as hard as possible, you will get what you want.
Yes.
Now, as we have already spent so much time with you, and I know your time is absolutely precious, I would like to just ask you one last question. Obviously, not last for our conversation, but yes, for this show. I would like to just ask you and understand how you have balanced your personal and professional life with such busy schedule in whole of your career. You have kept on achieving so many and number of things. How have you balanced?
Well, Divya, I think it started when I was about 12 at school. My mind was getting crowded with what I felt I had to do in terms of what my mother was asking me to do, make the bed, do this, do that. And then also what school was asking me to do, homework and this, that, and the other. So I sat down and I made a physical list. And I am now a complete and utter compulsive list maker. And I started around 12. And what it did, it helped me. So every night when I go to bed, before I go to bed, I look at my list, tick off what I've done, and then reassign the things I haven't done without feelings of guilt to the future. And in that way, I've been able to compartmentalize my life a little. It's a bit rigid, but it doesn't come across as that. It makes me happy and comfortable. And if I'm happy and comfortable, my family is. But they know about my lists. Everybody who knows about me knows about my lists. They're quite extraordinary. If you were to see my diary, I've actually got a physical diary I carry with me everywhere, and it's got everything in it. And any one week you choose, it's got masses and masses of ticks and crosses and additions and so on. But out of that mess, I make a list every week. We moved house after 34 years. We downsized house in January. So from October to present day, there's been another layer to all of that as well. And it's been at times almost overwhelming. And I've had to come up for air, but I've managed it. I've managed to arrange it. I've literally, managed the whole move myself. My husband's lovely, but he's not terribly organized in that respect. So I suppose I'm a bit of a control freak. I don't know. I just like to be in charge, in control. And I just compartmentalize work, home, chores, so on. So yeah, I mean, it's list making that's done it for me.
Wow, it's such an amazing experience just to understand that you're right. You tick, cross, and keep on doing it week by week. And you have so many journals with you. I love to do that as well. And you are such a positive person. I feel like there is a long conversation still pending. But yes, I'll not take any more of your time. And once again, thank you for being here. Thank you for motivating our listeners, learners, and everyone around, and especially me as well. And it is absolutely a humbling experience that you accepted and came and gave us this much time. Thank you so much, Karen, for being here.
Thank you, Divya. It was equally humbling for me to be invited. I am thrilled, and I'm so happy to have collaborated with you on this. Thank you so, so much.
Thank you so much. Have a great day. Have a great
And
evening.
to you, good evening, and enjoy your evening.